Hi there, my name is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about what it takes to win at the Appeals Council. Now, most of the videos I've done talk about up to the hearing stage, applying for benefits, filling out the reconsideration appeal, and then going to a hearing. Well, there is steps beyond that. If you lose at your hearing, you have the option of filing within 60 days of the receipt of the denial at the hearing, your unfavorable decision. You can file an appeal to the Appeals Council. And if you lose at the Appeals Council, you can file into federal court. The first step, and I want to talk about this, is the Appeals Council. And basically the Appeals Council is in Falls Church, Virginia, and basically that's where you would appeal an unfavorable hearing decision. I will tell you that the success rate at the Appeals Council is around 10%. About 1% of claims are actually reversed and paid at the Appeals Council. 9% are sent back to the administrative law judge, the same one who denied you, with additional instructions for another hearing. So one of the frustrating things is even if you win or you get your case reversed and remanded at the Appeals Council, it's going to go back to the same judge who denied you the first time. So be aware of that. People ask me, should I appeal or should I start a new application? I'll talk about that in a different video, but just be aware if you do file an appeal, A, it's going to take probably 2 years, and B, if you do win your appeal and the case is remanded, which is most likely the result, it'll be sent back to the same judge. Now, what are the grounds to win an appeal, or to have and you don't really win an appeal, your appeal would be granted and the case would be reversed and remanded back to the judge. Again, very rarely actually paid. So let's mostly talk about having it reversed and remanded, sent back. The Appeals Council is not going to review the judge's judgment, as it were. So if the judge reviewed your evidence and concluded that you have a herniated disc and that as a result of that you're limited to sitting for 45 minutes at a time and standing 45 minutes at a time, and you disagree and say, I can only sit for 15 minutes at a time, and I think the medical evidence shows that. Generally speaking, the Appeals Council is not going to disturb the judge's analysis of the evidence. If the judge finds that you're not credible, if the judge says this person has, misrepresented things to his doctor, and I find his complaints or her complaints of pain not entirely credible, the Appeals Council is not going to reverse on that, because the judge looked at the evidence, he heard you, or he or she heard you, so the Appeals Council is not going to reverse on that. What they would reverse on would be if the judge made an error in his or her analysis of your case. So, for example, if you have a herniated disc in the record, and it's clear you have a herniated disc, and the judge does not consider any impairments arising from that at all in asking hypothetical questions to the vocational witness, that, in my view, would be reversible. So, again, imagine you've got a case, you've got a herniated disc, and you testify about the medical record, there's an MRI report shows it's a herniated disc, and the questions the judge asked the vocational witness only talk about your depression and your mental health condition, or only talk about your diabetes, but do not mention any back pain or back problems, or don't even mention anything that could be related at all to a herniated disc. The judge has not analyzed all the evidence, and that would be reversible error, again, in my view. And in that situation, the Appeals Council would send the case back to the judge saying, you need to consider the impact of this claimant's herniated disc on his or her capacity for work. That would be something reversible. Another example, let's say that you are over age 50, you have a high school or less education and unskilled work background, and the judge denies your case based on the grounds that there are sit-down type of jobs you could do. Well, the judge would have, in that case, failed to consider the impact of the grid rules, because the grid rules apply to people with physical limitations. If you're over 50 with a limited education, limited work background, the grid rules very well may apply. Again, the Appeals Council might might conclude that, yes, the grid rules definitely apply and they pay your case, but they probably will send it back to the judge saying, run a grid rules analysis to see whether this person qualifies for the grids. That would be another example of a case that the appeals counsel might remand. And I actually had one of these several years ago where the judge just simply did not even consider the grid rules. When my client appeared to meet the grid rules, it was sent back. I made the grid rule argument and got approved. Again, unfortunately, the whole thing start to finish took 4 years, but that was an example of the judge making that kind of mistake. Now what I would do is, if the judge did not consider the grid rules, I would raise it specifically at the hearing and really kind of make a fuss about it, and maybe even do a post-hearing brief to try to get the judge to recognize that. I think it was just a little carelessness on the judge's part when I was just beginning when this all happened. But that would be an example of a reversible error. Another case I had that I won an appeal, the judge evaluated the case using the listings and said, well, this person meets the medical part of the listings, but his functional capacity is such that he could do a variety of work, of that type of job. The judge went through a full functional capacity evaluation. The problem was the listing only required the judge to consider 3 or 4 elements of function. I think in that particular case, it was ability to walk and ability to, I think use the legs for certain things, and maybe there was a pain element to it. But the point is, it didn't require the judge to consider using foot controls, or to consider absences from work, or consider those other things. So the judge kind of combined, in that case, a listing argument or listing evaluation with a functional capacity evaluation, and denied the case because there was enough capacity left over that the person could possibly work. But again, the listing didn't require that level of impairment. They required a diagnosis and certain limitations that were set forth in the grid rules. So I argued in my appeals brief that the judge demanded too much of the claimant in terms of the medical record, and that the listing in particular only required that the judge find 3 things, and all those three things were in the record. This case should be remanded back. The appeals counsel, in fact, did that. They remanded the case back and said to the judge, you don't need to do a full functional capacity evaluation. Just look to see whether this person has a difficult time walking without an assistive device and has a level of pain that would cause problems with attention and concentration. Again, I don't remember specifically what it was, but it was a much more limited, kind of an abbreviated functional capacity evaluation. So the bottom line is that if you're looking at going to an appeal, you really need to see that the judge made an error of analysis. But the appeals counsel is not going to second guess the judge's judgment and how the judge evaluated the evidence unless it is completely out to lunch. I mean, again, if you have a severely herniated disc at 2 levels and the judge says, well, I considered that and concluded this individual has only a very mild level of pain that would cause no interference at all with work functions, you can make an argument that the judge misread the evidence or did not give a fair reading of the evidence, and that needs to be redone. And I think you could make an argument to the appeals counsel the case needs to be sent back, and I would in that case to another judge to give a more fair reading of the evidence. But if you're going to focus your appeal on, I disagree with how the judge analyzed the evidence, and it's really more of a judgment call, and it's not something that is just blatant that the person, you're blind in one eye and the judge, decided you could see. If it's something not quite at that level, simply that the judge found that you could walk for 30 minutes instead of 20 minutes, that's not going to go anywhere. If the judge said that you're not credible when you say, yes, I am credible, I'm believable, that's not going anywhere. If the judge says, I think that alcohol is a continuing problem here, and you're saying, no, it's not, I stopped drinking 3 years ago, and my doctor was wrong saying that I am still drinking, that's probably not going to go anywhere either. So it's a very fine line, but again, the appeals counsel is not going to reverse a judge. It's not going to look over the judge's shoulder and say, you made an error in terms of your interpretation of the evidence, they're going to say you made an error because of how you analyze the evidence. That's the only way you win on an appeal for the most part. So that's the difference between a hearing where the judge is looking at everything and looking at the evidence and deciding what the impact of the evidence is on your capacity, on your ability to work, whereas the appeals counsel is more about, do the judge use the right reasoning, the right analysis to reach whatever conclusion he or she reached. We're not going to say the judge made the wrong decision. Even if we disagree with the judge's analysis, we're not going to reverse it. We can only say the judge used, if the appeals counsel is going to say, even if we disagree with the judge's conclusion, if he used the right analysis, we're not going to disturb it. We'll only disturb the judge's conclusions if he used the wrong analysis. That's the difference between a hearing decision and an appeals counsel decision. If you have any questions, please leave me a comment. I'm happy to try to answer those for you. I'm going to do, because I get a lot of questions about appeals, and I know a couple of really good appeals lawyers, and I'm going to try to get one or two of them on a roundtable. I've got a podcast that we're going to be introducing soon to the SSD Answers site. Right now it's on SSD Radio if you want to check it out, but it's going to soon be on the SSD Answers site, and I'm going to get some appeals people on that because it's more of a long-form discussion. We'll talk about appeals issues, so look forward to that. But for now, realize the big difference is that the appeals counsel is not going to second guess the judge's conclusions, but they will second guess the judge's analysis if it's wrong. I hope you found this helpful. Please give it a thumbs up if you did. Like it on Facebook. Leave me a comment. Again, let me know what you thought. Let me know if you have any additional questions. Happy to try to answer those. My website, as I mentioned before, ssdanswers.com. I've got a free Secrets to Winning Disability Survival Kit. A lot of great information there. It's delivered by email, up to 30 installments. I think you'll find that very useful. And if you're not already represented and you'd like me to take a look at your case, I've got a free case evaluation form there. Again, at ssdanswers.com. My name is Jonathan Ginsberg, and I look forward to hearing from you soon. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include, how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.